a right during the founding and settling of the American colonies, and later during the westward expansion. It is my personal belief that the cornerstone of a police state is the restriction on free travel, and registration of the means to do so, and the identification of those who wish to.
Clearly, sir, this is not 1215. This is 2010, and in this country we have laws and rules, regulations, statutes and acts to ensure our peace and security, and safety in public. I understand you are a peaceful man and are here in peace exercising your right to travel. However, except as otherwise provided in the Motor Vehicle Act, the owner of a motor vehicle or trailer must, before it is used or operated on the highway, obtain proper registration, insurance, licensing, and license plates to affix to the vehicle.
That such legislation specifically applies only to drivers and commercially driven motor vehicles. At this time I would like point to my legal briefing, which I duly presented to the Crown Attorney, who is here prosecuting on me on behalf of the state today. May I indulge the courts with my legal briefing regarding my right, and all of humanity's right to travel, which will furthermore clear up all confusion and understanding of my position, and proof of my innocence, and lack of jurisdiction?
I have a copy of your legal briefing with me here, sir. It is my position that the Crown has this legal document, thus it is of no consequence, and bearing at this time.
This is my legal briefing and defense. I attest this is of absolute consequence and bearing. You must allow me to submit my facts and state my defense. You stated this is a court of law, is it not?
Okay, fine, yes, you may proceed. Please be quick about it.
Submitted to the court is my legal briefing regarding the right to travel versus the privilege to drive. If ever a judge understood the public's right to use the public roads, it was Justice Talman of the Supreme Court. Justice Talman stated, "Complete freedom of the highways is so old and well established a blessing that we have forgotten the days of the robber barons and toll roads, and yet, under an act like this, arbitrarily administered, the highways may be completely monopolized. If, through lack of interest, the people submit, then they may look to see the most sacred of their liberties taken from them one, by more or less rapid encroachment." Robertson vs. Department of Public Works. The words of Justice Talman ring most prophetically in the ears of citizens throughout the country today, as the use of the public roads has been monopolized by the very entity which has been empowered to stand guard over our freedoms, that is, that of government. The most sacred of liberties of which Justice Talman spoke was personal liberty. The definition of personal liberty is, personal liberty, or the right to enjoyment of life and liberty, is one of the fundamental or natural rights, which has been protected by its inclusion as a guarantee in the various constitutions, which is not derived from, or dependent on, the Constitution, which may not be submitted to a vote and may not depend on the outcome of an election. It is one of the most sacred and valuable rights, as sacred as the right to private property, and is regarded as inalienable. 16 CJS, Constitutional Law, Sec. 202, pages 987. This concept is further amplified by the definition of personal liberty. Personal liberty largely consists of the right of locomotion, to go where, and when one pleases, only so far restrained as the rights of others may make it necessary, for the welfare of all other citizens. The right of the citizen to travel upon the public highways and to transport his property thereon, by horse-drawn carriage, wagon, or automobile, is not a mere privilege which may be permitted, or prohibited at will, but the common right which he has under his right to life, liberty, and the pursuit of happiness. Under this constitutional guarantee one may, therefore, under normal conditions, travel at his inclination along the public highways or in public places, and while conducting himself in an orderly and decent manner, neither interfering with nor disturbing another's rights, he will be protected, not only in his person, but in his safe conduct. Emphasis added. I am jur. First Constitutional Law, Sect 329, pages 1135. For years professionals within the criminal justice system have acted on the belief that traveling by motor vehicle was a privilege that was given to a citizen only after approval by their government, in the form of a permit or license to drive. In other words, the individual must be granted the privilege before his use of the highways was considered legal. Legislators, police officers, and court officials are becoming aware that there are court decisions that disprove the belief that driving is a privilege, and therefore requires government approval in the form of a license. Presented here are some of these cases. Case number 1. The right of the citizen to travel upon the public highways and to transport his property thereon, either by carriage or by automobile, is not a mere privilege which a city may prohibit or permit at will, but a common law right which he has under the right to life, liberty, and the pursuit of happiness. Thompson v. Smith.
Case number 2. The use of the highway for the purpose of travel and transportation is not a mere privilege, but a common fundamental right of which the public and individuals cannot rightfully be deprived. Chicago Motor Coach v. Chicago. It could not be stated more directly, or conclusively, that human beings have a common law right to travel, without approval or restriction, in the form of a license, and that this right is protected under the Constitution and fundamental human rights. Case number 3. The right to travel is a part of the liberty of which the citizen cannot be deprived without due process of law. Kent v. Dulles. Case number 4. The right to travel is a well-established common right that does not owe its existence to the federal government. It is recognized by the courts as a natural right. Shackman v. Dulles. Case number 5. The right of the citizen to drive on the public street with freedom from police interference, unless he is engaged in suspicious conduct associated in some manner with criminality, is a fundamental constitutional right which must be protected by the courts. People v. Horton. Case number 6. Users of the highway for transportation of persons and property for hire may be subjected to special regulations, not applicable to those using the highway for public purposes. Richmond Baking Company v. Department of Treasury. Case number 7. The acceptance by a resident of the state of a certificate of ownership or a certificate of registration of any motor vehicle or any renewal thereof, issued under the provisions of this code, shall constitute the consent by the person, that service of summons may be made upon him within or without the state, whether or not he is then a resident of the state, in any action brought in the courts of the state, upon a cause of action arising in this state, out of the ownership or operation of the vehicle. California Vehicle Code. Case number 8. Highways and the carrying places between the same shall be common highways, and forever free for the use of the traveling public, and all have the right to use them in a reasonable and proper manner without any tax, impost, or duty. Therefore the use thereof is an inalienable right of every citizen. Escobedo v. State. Case number 9. The right of a citizen to travel upon the public highways, and to transport his property thereon, by horse-drawn carriage, wagon, or automobile is not a mere privilege which may be permitted or prohibited at will, but a common right which he has under his right to life, liberty, and the pursuit of happiness. Slusher v. Safety Coach Transit Company, and affirmed by the Supreme Court in Thompson v. Smith. Other cases are even more straightforward. The right to travel on the public highways is a constitutional right. Tesh Lines v. Dan